Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today we're going to be talking about how Supreme Court Justice Amy Coney Barrett just absolutely screwed over the people of Illinois, and now the people of Illinois have something to be worried about come January 1st. So let's talk about what happened and where we go from here. Hey, real quick before we get this video started, I just want to say thank you to everybody for watching. I really do appreciate all the support. We are on our final push to 500,000. We're getting really close. So if you're watching this and you're not subscribed yet, it's free. It only takes a second to hit that subscribe button. Share this with your friends because people need to know what's going on out there. And a like button is always appreciated. So with that being said, let's talk about what's going on here. Okay, so let's go ahead and talk about what's going on here. So we're talking about the Illinois so-called assault weapons ban, the same ban that's having people currently register pretty much everything before the end of the year, and the same ban that's seeing mass non-compliance. I think at the time of this video right now, we're still sitting below 0.5% of compliance based on the numbers that we estimate are in the state. So again, there's mass non-compliance. People don't want to put up with it. They know it's unconstitutional. But the courts disagree. The district court and the appellate court for Illinois have said that not only, okay, are they upholding the ban in the state, but they don't believe that these so-called assault weapons, their words, not mine, they're not even protected by the Second Amendment at all. As a matter of fact, they don't even pass the text test. So under the text of the Second Amendment, they say that they don't belong because, well, they're uniquely dangerous or they're too much like military weapons, and they're not in common use for self-defense is the way that they put it. And so they don't even feel like they really even need to go to history and tradition because they say that it's just not covered. It's not protected. And that's, going from the district court up to the 3-judge panel for the 7th Circuit Court of Appeals. And the 7th Circuit Court of Appeals decided that they were not going to rehear this case en banc. And so the plaintiffs in this case asked for an emergency injunction from the Supreme Court. And the Supreme Court justice that oversees the 7th Circuit is going to be Justice Amy Coney Barrett. Now, remember, they weren't asking her to rule on this case and just completely end the ban in Illinois and say that all of these bans are unconstitutional. They were asking for injunctive relief, which basically stops enforcement of the ban, doesn't overturn it. It just stops enforcement of this ban while things can be litigated, right? And things can go through the court process until, the plaintiffs get a final word or whatever, right? So it's just that, or even at least until they can get a writ of cert up to the Supreme Court so that the entire Supreme Court can hear it. But since we're talking about only a couple weeks until this thing takes full effect and registration is closed, again, they were just asking for an emergency injunction. And she decided to deny that injunction, basically with no comment. She just denied the injunction. Now, there's a lot of people out there saying that, well, this is going to work out good for us in the end because obviously the NAGR, who is one of the plaintiffs here, is going to file that writ of cert up to the Supreme Court. And the Supreme Court is more than likely going to take this case, and that could end all of these bans across the country. So in the end, this could be fantastic. And while I agree that in the end, this could be fantastic for the people of Illinois, that sucks. It sucks for them because basically what we have here now is we've gone through the district court, the appellate court, and the Supreme Court, and this law has been allowed to take effect. And so for the people of Illinois, they're going to have their Second Amendment rights completely infringed starting in just a couple weeks. I mean, if you haven't registered and you pass the registration process or whatever, you're one of those people now who's going to be looking over their shoulder the entire time. So again, she wasn't asked to, issue an order on the entire case. She was just asked to provide relief for the people who are clearly having their rights infringed for a time being, right? And I feel like she could have done that. Now, this is, again, the second time the Supreme Court has denied to hear one of these cases out of Illinois. And people are saying that, again, the Supreme Court, they want to hear the entire thing. They want you to file a writ so that the entire circuit, the entire Supreme Court can take a look at it and figure out whether or not it holds up to text, history, and tradition and so forth. But man, how do you look at this case right here and say, no, I'm not going to provide injunctive relief only based on the evidence that I see, a clear infringement. And if you ask me, the law itself in Illinois is a complete slap in the face to the Supreme Court, who came out with the Bruin decision saying that this is the way you're supposed to look at Second Amendment cases. And you know what? You bet the people who would like to see our rights taken away in every state are absolutely celebrating this. I mean, this is a quote from one of the people from Brady, where it says, "The absence of any noted dissent illustrates just how misguided the gun industry's attempts to undermine the state's efforts are. We are grateful that while this case is being litigated, the quote-unquote assault weapons ban will stay in effect and continue to save lives in Illinois and surrounding states." So they're loving it. They're booking this one as a win. So if you weren't aware of that, I wanted to make you aware of it, and I also wanted to share my opinion with you, because I am sick and tired of the Supreme Court and the Supreme Court justices constantly not taking up clear-cut cases of infringement. I'm sick of them denying them. They say that the Second Amendment is not a second-class right, but they treat it completely different when it actually makes its way up there. If this was another case where they were saying, hey, people are no longer going to have free speech come January 1st of 2024. In order to have free speech, it can only be certain types of speech, and that speech, you have to have some type of ID proving that you're allowed to have free speech and so forth. If something like that went up to the Supreme Court, you could almost guarantee that they would take it and that they would provide injunctive relief. So they say one thing, do another, and it's really got me very frustrated. So again, I wanted to share that with you. Thank you all very much for watching. Please like, subscribe. You guys have a great day.